At 11 p.m. on Friday the 29th of March this year, the UK is due to leave the EU, with or without a deal, unless Parliament agrees to extend the 2-year deadline under Article 50. Huge uncertainty has characterised the last few months and weeks, and it remains to be seen just what will happen. Fortunately, there is no such uncertainty when it comes to the various annual employment law changes, some of which are due to come into force just 3 days later on Monday, the 1st of April. Every year, the national minimum wage and national living wage rates increase, and this year, it's no different. From the 1st of April, employees aged 25 and over who are entitled to the national living wage must be paid a salary that equates to at least £8.21 per hour. For employees between 21 and 24 who are entitled to be paid the national minimum wage, their rate increases to £7.70. Between 18 and 20, it increases to £6.15. And for employees over the compulsory school age and who are 17, their rate increases to £4.35. As for apprentices, well, their rate increases to £3.90, unless you happen to be on a particular BBC reality programme, in which case it's whatever rate Lord Sugar decides you're worth. Statutory rates for certain employment entitlements also go up on the 1st of April. In particular, SSP rises to £92.45 per week, and SMP and SAP both rise to £148.68 per week. Auto-enrolment contributions for employee pensions also increase, but not until Saturday the 6th of April to coincide with the start of the new tax year. Employer minimum contributions rise from 2 to 3%, and minimum contributions rise for employees from 3 to 5%, meaning that the total minimum contribution will stand at 8% from the 6th of April. And this is the last of the incremental changes that were set out when the auto-enrolment scheme was first launched. For private sector employers with a headcount of 250 or more employees, remember that the second annual deadline for submitting your gender pay gap report is Thursday, the 4th of April. Results must not only be published on your website, returns must be made so that your report also appears on the designated government website. It's likely to be less painful second time around as we are all more familiar with what's expected, unless of course you're an employer who's grown their headcount in the past 12 months and you now find yourself caught by the regulations for the first time. Employment status and whether someone working for you is an employee, an independent subcontractor or a worker is one of the hottest topics in employment law at the moment, not least because of a number of recent high-profile cases, but also the government's review into this area. In the context of that debate, an important change comes into force on the 6th of April, when workers will, for the very first time, be entitled to receive an itemised pay slip from the company or the organisation they're working for. Currently, something only that employees are entitled to. Regulations coming into force which employers who retain workers will certainly need to be aware of, because a failure to provide a pay slip to those individuals who are workers could well lead to an employment tribunal claim. Now, time does not permit me to outline any further proposed changes that are on the horizon this year and which could well have a significant impact. So please, if you are already a Peninsula client, do keep in touch with your advisor. And if you're not a Peninsula client, then do get in touch to find out more about how Peninsula can help protect your business, particularly in these uncertain times, and whether these last few minutes provided you with a welcome distraction from Brexit. Well, I'll leave you to judge that.